I'm Mary Trosco, CLIA's Executive Director, and it's my pleasure to welcome all of you to tonight's presentation on consumer law. We acknowledge that CLIA's office is located on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene people, the traditional homeland of the Métis people. Winnipeg's water is sourced from Shoal Lake 40 First Nation. Now, I'd like to introduce our presenter. Silvana Buccini is the Consumer Services Officer with the Manitoba Consumer Protection Office. She's held this position for over 10 years and is very well versed in consumer transactions and the legislation the Consumer Protection Office administers. Silvana's presentation will briefly review some of the biggest transactions engaged in by consumers, like vehicle purchases and repairs, home renovations, direct sales, and internet agreements. So thank you, Silvana. I'll turn over to you and I'll mute myself.
Thank you, Mary, and thank you everyone for attending this evening. As Mary stated, I am Silvana Buccini. I'm a Consumer Services Officer with the Manitoba Consumer Protection Office. I have been with the Consumer Protection Office for 11 years now, so I've definitely seen my fair share of interesting scenarios come across my desk. And this evening I will be presenting to you on, I guess, some of the more touched upon areas of our legislation. If you have any questions, please ask if you're comfortable while I'm on the topic. That way, at least, if we're on the topic, we can maybe have a better discussion. And at the end of the presentation, if you wait, I may have forgotten what I said, so I may not be able to speak to it as well as I would normally like to. That being said, I'm going to share my screen with you so you can see my presentation. Okay, hopefully everybody can see that now. Okay, so here I have our contact information for the office. So should you have any questions or concerns at a later date, you can refer back to this information. So a quick introduction about our office. We were established in 1970 for the purpose of administering the Consumer Protection Act. Our services have grown since then in terms of the legislation that we administer. We'll touch on that briefly. Our services are available to all Manitobans at no cost. You pay taxes, therefore you get the services of the government at no additional cost. It is a question that comes up fairly regularly with consumers. So I like to touch on it in the introduction whenever I do these types of things. Our legislation also applies in individual to business transactions. Our legislation does not apply in a business to business transaction. So if the concern that you have is regarding your business and it's with another business, unfortunately, that's not something that our legislation would cover. And so it must be a retail sale or transaction for your personal use. So the role of the Consumer Protection Office. We administer the Consumer Protection Act, the Business Practices Act, the Personal Investigations Act, and the Hearing Aid Act. Recently, we also absorbed the Film Classification Board Act, because there's no more film board, Manitoba Film Board. It's all been revamped and restructured. So our office has kind of taken that on. We've also adopted the Amusement Act as well. I'll be honest, I've never worked with either one of those acts, so I really don't know much about it. We had an officer who was working exclusively with those. He came over from the film board. All right, so major functions. We mediate and investigate consumer complaints. That is what I do generally on a day-to-day basis. We have two sides to our office, the enforcement side, which is where I work, and then we've got our licensing side. The licensing side of our office registers and provides authorization to businesses like collection agencies and collectors, vendors and direct sellers, which would be those who attend your home or call you unsolicited over the phone to sell you a product. So alarm systems, for example. The company needs to be licensed and the individual attending your home must also be licensed. Under certain circumstances, the Business Practices Act allows our office to make recommendations to justice regarding prosecutions. So we have the ability under that specific act to move forward with potential charges if they are accepted by the Crown. Usually we try to tack on charges to the police charges as well, either RCMP or WPS. And we do that because oftentimes if they're breaching our act, it's probably also criminal. So it makes it a lot easier for us to press charges if we've also been able to tack them on to criminal charges as well. We identify marketplace problems. So we have a process of intake where we receive calls and emails and sometimes walk-ins, of course, pre-COVID, from consumers regarding their particular situations. So if there's something new that's happening in the marketplace, we hear about it through the complaint process in our office, but we don't actively monitor the marketplace. We also provide information and education through presentations such as I'm doing today. We do a lot of presentations to seniors' homes. We do a lot of presentations to new immigrants and pretty much anybody else who actually asks for our services. We're always more than happy to come out and provide a presentation on different topics: consumer law, frauds and scams, etc. We also consult and cooperate with other enforcement agencies. So like I mentioned, the RCMP or Winnipeg Police Service. Sometimes we are in communication with the Competition Bureau or the CRTC, depending on the situation itself. Very common misconceptions. We're not a court and we do not make rulings. This is something that consumers ask of us on a regular basis. Unfortunately, that's not something that we have the ability to do. In certain situations, just have to go to court because we can't decide who's in the right and who's in the wrong. And if mediation has reached an impasse, court is usually the next recommended step. We're also not a reporting agency. We often get mistaken for being very similar to the Better Business Bureau. We are not. So anything that comes into or goes out of our office is all confidential by statute. So if a consumer sends a complaint into our office regarding XYZ company and you contact our office asking if we've got any complaints against XYZ company, unfortunately, we would not be able to provide that information. That being said, however, if you contact our office and ask if a certain vendor or direct seller or collection agency or collection agent have a license, that is information that we can provide to you. We just unfortunately can't tell you if we've got any complaints against any of the companies. As I stated, we actually don't monitor the marketplace. So we don't set product standards. We don't look at pricing. We don't look at the ratings of different companies. It's just not within the scope of our office. We're also, despite our name, not a consumer advocate. We are a third-party neutral mediator. So we don't take sides and we don't advocate for anybody. We just enforce the legislation that we are provided. So the Consumer Protection Act, includes a number of different provisions. We're not going to go through all of these this evening. Time doesn't allow, and eventually you're going to lose interest. So what I can say is that we do administer legislation in a lot of these areas. Cost of credit is one that I won't go over, but that is one that raises a lot of questions as most people aren't quite familiar with what that is. So cost of credit disclosure, if you have a finance agreement for fixed credit, we'll say a lease agreement, potential information regarding open credit, if you've signed up for a credit card, etc., all of those individual documents must disclose certain information to consumers. And that's what the cost of credit disclosure legislation regulates, is what information must be disclosed to consumers along with other information that goes along with those types of agreements. For example, repossession, when it comes, seizure or repossession, I should say, once it comes to, a finance agreement, what happens, what information must be disclosed regarding lease advertising, that kind of information. And then we've got warranties, payday lenders, direct selling, collection practices, internet agreements, prepaid services. Prepaid services refer to certain types of contracts, and those are very specific contracts. in which payment in advance of using the service is required. Okay. And then you've got your prepaid purchase cards, such as gift cards, and then motor vehicle disclosure. We also touch on motor vehicle work and repair legislation and a number of other areas, but these are probably the more utilized sections of our legislation. So we're going to start with warranties today. A warranty is a company's promise that the product is going to do what it's supposed to do for a certain amount of time. So it could be a year, it could be 5, it could be 10. If you're talking shingles, it'll be 25 to 30 for most of them, right? Certain items, certain products will have different lengths, different warranty lengths on different components. So for example, a refrigerator, there's generally a 1-year warranty on a refrigerator, but there is a 5-year warranty, generally speaking, on the compressor in the refrigerator. So it depends on what the issue is with your refrigerator or with the item in question, and that's going to dictate how long your warranty is and whether or not there actually is any warranty coverage. Warranty cards, I don't know if you all remember warranty cards or not, but they still have different forms of warranty cards. Now, a lot of times manufacturers will ask you to go online and register your product instead of having the actual paper card that you used to mail in. The reason for that is, should the seller, right, the company that sold you the product, go out of business, registering your product with the manufacturer allows the manufacturer to know that you did purchase this product, when it was purchased, all of that pertinent information. So if you have a warranty issue, you can go to the manufacturer and it will be covered under your manufacturer warranty if the manufacturer warranty applies. Our legislation holds the seller personally liable for all warranties, whether it's third party, in-house, or manufacturer. Meaning, if I have a problem with my television set, for example, I will go back to the place where I purchased the television, advise them that I have an issue with my warranty or with my television set, and they're responsible for following through on the warranty promises made by the manufacturer. For example, if a technician is to be sent out, the seller is to send a technician out to my home to look at the television set. Then at that point, the manufacturer will determine if it should be repaired, if it should be replaced, or if they should refund it. Now, as a consumer, I can say, I just received this coffee table. I ordered it from a seller. It's taken 3-4 weeks to arrive and it's scratched. And the seller says, we'll send out a technician to try to repair it. I don't want a repaired coffee table. I paid for a brand new coffee table. I'd like a brand new coffee table. Unfortunately, you don't always get the choice, and neither does the seller. It is up to the manufacturer to make that final decision. Now, usually the first step is to send out the technician. The manufacturer wants to know how bad is the damage, right? Can this be repaired or not? So our recommendation is always let the technician come out, see what the technician has to say, and then take steps to try to reach the resolution that you're hoping for. Read warranties carefully. We always recommend you read everything carefully, but read your warranties carefully as well. Not all warranties cover everything. So sometimes you're going to get a warranty that is a limited parts warranty and not a labor warranty, meaning as a consumer, you will always be responsible for the labor to pay for the labor costs, and you might be responsible for some of the parts as it's a limited parts warranty. Sometimes you will get a warranty that covers both labor and parts, which is fantastic. But that's not always the case. Ideal situation, but unfortunately that's not always the case. Also, before getting any technician to service any of your products, find out which service providers in Manitoba are authorized dealers of that manufacturer. This can usually come into play with either appliances or electronics a lot of times. Manufacturers will choose certain authorized dealers that they allow and that they trust and that I guess they've trained to service their products. If you choose a technician or a repair facility that is not authorized by that manufacturer, you run the risk of voiding your warranty, which could be problematic. As I stated, some warranties may limit the protection they offer to the person who originally bought them. And I know this sounds really strange, but garage doors, if you get a brand new garage door, right, that opens electronically, not manually, usually the warranty is non-transferable on those items. I don't know why. I can just tell you that from what I've seen, that is one of the only products that I've seen come across my desk in the last 11 years that has a non-transferable warranty. That's not to say that there aren't other warranties that are non-transferable. However, that one I know for sure is non-transferable. So if you're buying something, you may want to make sure if it's, if it's a refurbished or a used item, or if you're getting it, from somebody else, make sure that the warranty is transferable. Because if the warranty is one of the items that you say, okay, well, I'll take the risk on this, or I'll take the chance on it because there is still a warranty on it, you're going to want to make sure that should you need to use that warranty, you can, and make sure that warranty is transferable. Which brings me to the as-is floor models. As Winnipeggers, we always love a good deal. At least I know that I do. So, the as-is floor model is always somewhat attractive if it's in good condition. Unfortunately, those items usually do not come with a warranty. So one, you're going to always want to ask whether or not the as-is floor model comes with a warranty. And two, if the answer is no, it doesn't come with a warranty, make sure that you take a really good look and a really good walk around to note where any damage may be on that as-is floor model, because you want to ensure that once it arrives at your home, it's in the same condition. I would also recommend in an as-is floor model that you take photographs of the item or even a video while it is in store, so you have the substantiation to show this is the condition it was in. Because sometimes things can happen in transport, and if it doesn't have a warranty on it, you want to be able to show, look, this is not how it was when I purchased the item. Something happened to it in transit, and this is your responsibility, because then that will allow you to have a warranty, as the seller is then responsible for ensuring that you receive that item in the same condition in which you purchased it. Extended warranties. Extended warranties are offered on everything these days, I think. Even video games. And I mean, granted, the cost of video games these days, I'm not surprised. However, extended warranties are extra protection at a cost. Now, the decision as to whether or not to purchase an extended warranty should come down to answering a couple of questions. When does the extended warranty begin? Does the extended warranty begin on the day you purchase the item, or does the extended warranty begin after the manufacturer's warranty ends? Also, what you want to know, and that question is important because you're going to want to know, does the extended warranty give me any additional coverage on this item that the manufacturer's warranty doesn't provide? Because if it starts on the same day that you purchase it and it doesn't give you anything extra that isn't covered by the manufacturer's warranty, then why are you spending money on the extended warranty, right? So you're going to want to check in to see what's covered, what isn't, and when your extended warranty starts to determine if there is a benefit to you or not. In Manitoba, all goods and all services come with an implied warranty, and this is in the Consumer Protection Act. Now, implied warranties are very general in nature as addressed by the Consumer Protection Act. And by that, I mean, it states that an item should work properly for a reasonable amount of time. Now, reasonable is not something that is defined by our legislation. And as we all know, reasonable is a subjective term. What might be reasonable to me may not be reasonable to another person, and vice versa. So the implied warranty is there, and the case can be made for implied warranties, which is something that we do in many cases. However, it's not a guarantee. Okay. So if you agree to something else in writing in a contract, that may supersede the implied warranty, depending on what it is that you've agreed to and the situation itself. Generally speaking, though, the legislation will supersede any sort of a contract that you may have signed. But again, it's going to depend on the situation and the way in which, what it is that you've signed off on and what it is that you've agreed to. As I stated, sellers in Manitoba are personally liable for all warranties, manufacturer, third party, or in-house. Your responsibility as the consumer is to get your item to the seller, and then they have to take care of it from there. So if it has to be shipped away to be repaired, that's at the cost of the seller, not the cost of the consumer. Okay? You don't have to pay for any of those shipping charges. You don't have to. You're not responsible for any costs, obligations, or liabilities. If a seller tries to send you directly to the manufacturer, the answer to that is no. This is your responsibility under the Manitoba Consumer Protection Act. And part of the educational component that we offer, that I provided in our introduction, is to also contact different sellers to advise them of what their responsibilities are in Manitoba with respect to warranties. And this is something that we do on a regular basis. Payday loans. We have been regulating the payday loan industry since October of 2010, I believe is when the legislation came into force. So we regulate the industry, we regulate the fees and the interest rates that lenders may charge. There is also a licensing requirement. So you cannot offer payday loans, offer or arrange or negotiate, I believe, a payday loan without a license to practice or to operate in Manitoba. Online lenders technically would need a license if they are going to lend to Manitoba consumers. It's a lot more difficult to track down the online lenders. One day they're up, one day they're not sometimes. And being able to monitor the internet is, in that respect, can be very difficult. However, whenever we hear about a new lender, we do send out a letter and we send out a licensing package, and we advise them of the law and we advise them of their responsibility that they need to have a license in order to operate in Manitoba. We also have record keeping requirements and inspection records. We have the right to access and inspect their operations and their records, so we can walk into any payday lender, show our identification, provide them with the legislation, and ask them questions and obtain documents. In these types of scenarios, we don't necessarily need to have a complaint in order to go in and do an investigation, right? We can just pop in for an inspection to ensure that the legislation is being complied with. The fees, however, are set by the Public Utilities Board, and there is a regular, they reevaluate the fees. I believe it's every 3 years, I want to say. And we have specific payday loans officers in our office that handle all of the payday loans and do all of the inspections, all the inspection reports, and deal with the payday lenders directly. We also have high cost credit, which is very similar. As I stated, all payday lenders in Manitoba must be licensed. In Manitoba, lenders cannot charge more than $17 for every $100 they lend. Okay, and that has to include any fees or I guess we'll say insurances that are mandatory. Can't be more than $17 per $100 that they're allowed to collect in return. There's also a 48-hour cancellation clause, assuming you have not used any of the funds, of course, that have been provided to you. Most consumers are not aware of that 48-hour cancellation clause, however, it's there. And you don't have to buy the extras. There are some lenders, I shouldn't say a lot of lenders, there are some lenders, mostly those that are online and not necessarily licensed with our office, require that you take a debit card, require that you take some sort of an insurance, et cetera, et cetera. And these are the extras. There's technically optional services, but they're presented as being mandatory, and consumers are told they have to take them. Consumers don't have to take those. Door-to-door sales and telephone solicitations. So this is what we call direct selling. So any sort of door-to-door flyer, telephone solicitation, home parties, candles, Tupperware, etc. All of those companies and the individuals that are trying to sell you the products must be licensed in our office. Now, if you're not sure if a company or an individual who is coming to your door or calling you or coming to your home for a home party is licensed, please give our office a call. We will be more than happy to look into that for you. With direct sales, because they are considered high pressure sales, because they are at your door or over the phone in the moment, right? We do allow a cooling off period with these particular types of loans. So you have a 10-day cancellation clause for that contract, and that starts on the day that you receive a copy of your contract. Cancellation must be done in writing, and it must be done in a way in which you can prove. Now, the Consumer Protection Act requires vendors to have an address for service in Manitoba on their contract, and it must tell you on the contract where to send your cancellation letter. If that information is not on your contract, you can give our office a call and we can assist you in determining where that letter must go, but it must be done within the 10 days. So it must be the postmark deadline is that 10-day cancellation. And my understanding is that weekends also count in that 10-day limit that you have. Cancellations cannot be done over the phone. Sometimes what our office will recommend is contacting the company by phone and saying, look, I'm looking to cancel. This is not something that I want. But then you must follow up with that written cancellation. Okay. Without that written cancellation, there's no way to substantiate your cancellation or the day on which this took place. Now, sometimes businesses such as alarm companies, when they come to your door to sell you an alarm, if you sign off and you agree, they will come later that day or first thing the next day to install all of the equipment. That doesn't negate your right to cancel. So even if the equipment is in your home, they must come and remove that equipment from your home upon your cancellation and then provide you with a refund of anything that you've already paid up to that point. And they have 15 days to provide you with that refund after the cancellation. Usually if there's equipment in the home, they'll remove the equipment first and then provide the refund because they want to ensure that they're going to get their equipment back. But that doesn't necessarily, just because there's equipment there, it doesn't mean that you don't have the ability to cancel. Now, in very specific situations, we do have a section of our legislation that addresses extended cancellation rights as they pertain to direct sales. So for example, if the vendor or the direct seller that attends your home or calls you over the phone, etc., are not licensed, if either one of those two are not licensed, you would have up to 1 year to cancel. Okay. There are other situations in terms of information that might not be disclosed on the contract that should have been disclosed, etc., that would also allow up to a 1 year cancellation. But those are the two most identifiable reasons in which a consumer would have the ability to cancel within 1 year after that 10-year period or 10-day period. My apologies. If you don't realize any of this until the 1 year after the 1 year has lapsed, unfortunately, there are no cancellation rights beyond that 1 year period, and our office is unable to assist you in canceling at that point. However, we might be able to look at your contract under a different section of our legislation. For example, leases. If you've leased a hot water tank or some sort of HVAC equipment possibly, we would be able to look at it under our lease agreements legislation, but that doesn't allow for the right of cancellation. But we would still be able to look at it, and there might be some assistance that we could provide with respect to a lease agreement in those types of sales. Always watch out for the high pressure sales tactics. A lot of consumers feel pressured and they feel that they must sign in order to get rid of this person because they're being really pushy, they don't want to leave, they keep coming up with different ways to try to sell you on this item, and some people just sign off to get rid of these individuals. Please try not to do that. However, if you are in a situation that you have done this, contact our office immediately. We will assist you with the cancellation process because you have that 10 days in which to do so. If the company tells you you're not allowed to cancel within that 10 days because equipment has been installed, or, oh, well, we've financed this, we've already been paid out, doesn't matter. You have every right to cancel within the 10 days. You don't even need a reason. You could just say, you know what, I decided I don't like my salesperson. I just want to cancel this product for that reason. And you can do that. You don't even have to give them a reason, period. And always remember, if it sounds too good to be true, it usually is. Kind of the motto of our office. Buying a vehicle. Usually second to buying a home, purchasing a vehicle is the largest purchase most people make in their lives. It's also impressive to me how quickly we make that decision to purchase a vehicle, without reading everything through thoroughly. And I understand that it's all very exciting. However, there's a lot of things we see with respect to motor vehicle sales. Fast talking salesperson, excited consumer, and you have a really bad combination. Something to remember is whether buying new or used, you do not, under our legislation, have the right of return. Meaning once you've purchased the vehicle, once you've signed on that dotted line, there is no possibility of returning that vehicle and getting your money back unless A, the dealership allows you to, or B, a court says that they have to give you your money back and take the car back. Those are the only two situations in which you would be able to do to return the vehicle and get your money back. If it's a new vehicle, you might have some rights under CAMVAP, the Canadian Motor Vehicle Arbitration Program. They do have a potential for a buyback with certain manufacturers, but it's a very specific qualifications that you would need to qualify for that program, and that's only one of the options. There's no guarantees. But this is a very large misconception. Consumers seem to think that they have, or that there is a 24-hour or 48-hour, I've even heard a 30-day return policy on vehicles, and unfortunately that's just not true. Deposits. In Manitoba, deposits are non-refundable unless otherwise stated in writing. So if you're shopping for a vehicle, don't leave a deposit unless you are 2000% sure that this is the vehicle that you would like to purchase. Unfortunately, I've seen situations in which consumers have left deposits because they've been told that the deposit is refundable if they change their mind. But then they go back and the salesperson says, nope, sorry, non-refundable, right? And the general manager of the dealership usually reiterates that same thing, unless there's a reason for it. So for example, if you apply for financing and you're unable to secure financing, and that's the reason that you can't purchase that vehicle, in most situations, the dealership will A, try to find another solution for you, like getting you into a vehicle that's less expensive, or giving you back your deposit if buying a car just isn't in the cards at that time. However, I had a consumer contact our office saying that he had $1,500 stolen from him. My first reaction was, maybe you should call the police. But once he explained that he was car shopping and went to 3 different dealerships, like 3 different vehicles, left $500 at each one of those dealerships, I understood why he called our office. And it broke my heart to tell this young man that he may have lost out on the $1,500. He thought he was just leaving the deposit to hold the vehicle until he's made his decision. Nobody told him that it wasn't refundable. I don't know if he asked the question or not, but he was never told that he would lose that money if he decided that he wasn't going to purchase that vehicle. So in situations where you have worked with the salesperson on numbers and stuff, and they've sent you home with, this is what your payments would look like, this is what you would get, etc. And you've left the deposit on the vehicle, $500, $1,000, whatever it was that you've left on the vehicle, just to hold it while you go home and you think about it. You can go back if you've decided that you don't want to purchase that vehicle anymore because you haven't signed a bill of sale yet at this point. You've only just gone through the worksheet and worked out the numbers. You can cancel that sale at that point. However, you may be out the deposit still, even if you don't go through with the purchase. Okay. So before leaving a deposit, get it in writing from the dealership that the deposit is fully refundable within a certain period of time, say 24, 48 hours, for any reason. If the dealership is not willing to put that in writing for you, then at that point you may want to walk away and be sure that this is the vehicle that you want to purchase before putting any money down, or be prepared to walk away from that if you decide you don't want to purchase this vehicle and you may not be able to get that money back. Always comparison shop when it comes to purchasing a motor vehicle. And the reason I say that is because you want to have a good car buying experience. You want to feel as though the dealership is being straight with you, that they're not telling you things just, you know, for the sale, etc. So you're going to want to talk to family, friends, people you know, and ask them where they purchased their vehicle, how their experience was, who they dealt with, right? Those kinds of questions. Because if it is a new vehicle, you may have to go back to that dealership on a regular basis for maintenance and service in order to maintain your warranty on that vehicle. And if you didn't have a good car buying experience, you're not going to want to go back to that dealership, and it's just going to put a damper on the whole thing. Also, check with the Better Business Bureau. See what kind of a rating the dealership has, what kind of complaints you're seeing coming up regarding the dealerships. And if you start seeing the same complaint coming up over and over and over again with the same dealership, that might raise a red flag going, okay, this may not be just a one-off. If you're buying a used vehicle, we always recommend that you have your own mechanic look the vehicle over, and I'll explain why. In Manitoba, the regulation of the motor vehicle industry is done by two parties, MPI and our office. MPI regulates safety certificates, the information that has to go on the sales document. They regulate the licenses for dealers, car salespeople, etc. Now, our office regulates the advertising of the vehicle, and motor vehicle information disclosure, the transaction itself, the other side of things. When you purchase a vehicle, new vehicles come with a new vehicle information sheet, which is called a NIVIS, but used vehicles come with a safety certificate. So it has to come with the safety certificate. If it's not a past safety certificate, meaning if any of those items have failed and they haven't fixed them, they have to disclose to you that here's a safety certificate, but this safety certificate has not passed A, B, and C, and you would be responsible for fixing those items. You can't register the vehicle without a past safety. So the safety regulates only safety related items. The Consumer Protection Act regulates the history of the motor vehicle. Has it ever been in an accident over $3,000? Was it ever registered in a different jurisdiction? Has it ever been immersed in water up to the floorboards? Was it ever used as a daily rental or an emergency vehicle? That type of history is what our legislation requires consumers be disclosed. However, mechanical issues with the vehicle are not regulated by legislation, so they don't have to disclose to you any mechanical issues with the vehicle if they're not safety related. So with a used vehicle, always take it to your mechanic, ask them to look it over because you're looking to purchase it. So you want like a pre-purchase inspection to know, is there something currently wrong with it? What stuff might be coming up, right? Oh, you know, your brakes are you're gonna need new brakes in the next 6 months, depending how you drive. You know, you might need this, you might need that. Or this this vehicle is mechanically sound, you're making a good purchase here. If the dealership is not willing to allow you to take the vehicle to your own mechanic, you may want to give it further consideration, because you have to ask yourself, why not? Warranties. Dealerships like to offer warranties. You're going to also want a comparison shop on the warranties. You're going to want to ask a lot of questions about warranty. What kind of warranty do they offer? What kind of extended warranty do they offer? Do I need an extended warranty? If I am purchasing a brand new vehicle and I have a 3-year manufacturer's warranty and it covers everything aside from wear and tear, like, you know, brakes, that kind of thing, battery usually, what does the extended warranty get me? Or does the extended warranty start after the manufacturer's warranty ends? Okay, so these are kinds of questions that you're going to want to ask. And costs also vary for warranties, so you're going to want to shop around. Some warranty places will sell direct to consumer, and you don't have to go through the manufacturer. You can actually get it cheaper if you go directly to a third-party warranty company to purchase a warranty. With brand new vehicles, you can buy a gap warranty. They sell those on brand new and used vehicles, but you can buy a gap warranty, which that warranty will, or I guess that insurance will cover the warranty or cover the gap between what, if you get into an accident, the vehicle gets written off, what you get from Manitoba Public Insurance and what you still owe on your loan. And that insurance will cover that gap. That might be a question better answered by Mary, because I'm more than happy to provide the PowerPoint presentation to Mary if she's got a place in which it will be available. That's I'm more than happy to make that available to her and to everybody here. But Mary, that you might want to have to field that one. You're welcome. Also, read everything. The time to bargain is before you sign. If you've signed a bill of sale, you have accepted the terms, conditions, and numbers that are present on that bill of sale. Right? So make sure that the information that's on there is accurate and factual. Okay. Is this what you agreed to pay for the vehicle? Are they charging you for anything that they didn't ask you about, or that you're not familiar with, or something you didn't agree to? Okay. If you don't understand something on that bill of sale, do not sign it. Okay. Also, don't sign any contract that has any blanks on it. If they haven't filled in the numbers and said, you know what, we're really busy today, just sign here, we'll fill everything in later. We know what the numbers are, just trust us, it's great. Famous last words, right? I trust them, okay? Don't trust anybody with your money. You work very hard for it. Make sure that what is on that bill of sale is what you have agreed to. If there are any discrepancies whatsoever, ask about them, okay? Don't just accept and say, oh, okay, this must be correct, or I trust this individual and I will, you know, I'm sure that what they put down is correct. I'm just going to sign and we'll move from there. So administrative fees, allow me to talk to you all about the administrative fees. Motor vehicle disclosure, hang on, let me see how far. There's the advertising. So I will get to the administrative fees once we get to the advertising, because that's where I get into the admin fees. So I will get there in just a moment. I just wanted to see how far down it was. Also get a copy. Don't ever sign a document and not leave with a copy of that document. If they say, if they ask you to sign something on a tablet, either look at what they're asking you to sign before signing it on the tablet, or ask for a paper copy and say, I'm not going to sign on your tablet. I want a paper copy of what I'm about to sign so that I can look at it and review it. Tablets have become very commonplace in terms of asking consumers to sign them and asking them to just sign here. All the information we discussed is all correct. It's all in there. Great. Then I guess you wouldn't mind showing it to me. Okay. So if you do sign on a tablet and they say, oh, we'll email it to you, you know what? Email it to me right now. Most of us have smartphones and they usually go to our smartphone, or we should be able to check. Don't leave without making sure that there is a copy either in your hand or in your inbox. motor vehicle disclosure, information disclosure. And this is what I had discussed just, I guess, 2 slides ago regarding the history of the vehicle. So I won't spend a ton of time on this, but I will go through it a little bit. This legislation came into force December 31st of 2011. Manitoba car dealers must provide consumers with very specific information at the time of sale, and it must form part of the bill of sale. Okay, they cannot, and a lot of dealers do this, and I've had to correct them on this, they cannot just provide you with a Carfax or a car proof and say, here you go, there's your motor vehicle disclosure, sign here, you know, all the information. No. And I will explain to you why they can't just hand you one, because it doesn't meet our requirements. So motor vehicle disclosure must be done both orally and in writing, and it must form part of your bill of sale. So it must be provided to you. You must go through that before you sign off on the bill of sale, because you have to have that information to be informed before you're able to move on and sign off to purchase the vehicle. Disclosure must be done to the best of the dealer's knowledge. Okay, and the information that's provided is information that the dealer knows or ought to have known using reasonable care and due diligence, meaning, did the dealer take any steps to find out this information, right? Did they run a motor vehicle history report? If the vehicle was a trade-in, did they obtain this information from the previous owner? You know, did they check the registration on this vehicle, etc.? That's information they ought to have known using that reasonable care and due diligence. So here's some steps that are considered reasonable to identify information, right? Manufacturer, auctions, MPI. If a dealership purchases a used vehicle at the auction, such as ADESA, they will get a Carfax or a car proof with that vehicle. That is the standard that ADESA now provides with their vehicles when you purchase a vehicle from them. And the excuse of, oh, well, I'm new, I didn't know, doesn't fly. The legislation holds everybody who works at that dealership accountable for knowing the legislation. You are responsible to know it. You work here. I don't care how new you are. You need to know this legislation, and that doesn't provide an excuse, we'll say, for not giving this information to a consumer. So here's some of the basic information that has to be disclosed. Must disclose whether the vehicle is new or used. And they also have to provide the vehicle identification number, or the VIN. Then there's a list, a specific list of yes or no statements. So the dealership has to go through each one of these with you and check off yes or no, because that's information that you have to know. And the Carfax car proof doesn't list all of these items and doesn't provide all of this information on their report, which is why it doesn't meet the requirements. So we don't consider it to be compliant if the dealership just provides you with a Carfax or a car proof and doesn't provide you with a separate document that goes through these specific yes or no statements. So, has the manufacturer's warranty been canceled? Has the vehicle been declared a lemon in another jurisdiction? Canada does not have lemon laws, so there is not a possibility that the vehicle can be deemed a lemon anywhere here in Canada. However, the United States does have lemon laws. So when a vehicle's been deemed a lemon, they can't sell it there. Sometimes they ship it up to us and we can sell it here, right? So now dealerships have to disclose to consumers if this vehicle has been deemed a lemon somewhere else. Has the vehicle been a CAMVAP buyback? Right? Has there ever been any flood damage or fire damage? Right? What is the previous use on the vehicle? Taxi, emergency vehicle, rental of any kind, right? Has the vehicle ever previously been written off and have a title of salvage? The reason that's important is because if you purchase a salvaged vehicle and you get into an accident with it, they will automatically write that vehicle off. So you as the consumer need to know that information, because that might impact whether or not you purchase this vehicle and at what price you would be purchasing the vehicle. Rebadged. So has the vehicle been subjected to aftermarket, we'll say, improvements or modifications that would take it from, for example, being an XL to being an XV, right? A model up. So it's not really an XV, it's just masquerading as one, right? As a consumer, you need to know, right, what exactly it is that you're purchasing. And is this vehicle materially different from the original or the advertised specifications? Other information that has to be disclosed. Was the vehicle damaged in an accident and the cost of the repairs from an incident over $3,000? Now, if the vehicle was in 3 different accidents and it was $1,000, $1,000, and $1,000, that doesn't have to be disclosed. If the vehicle was in an accident and one accident was $3,000, that information has to be disclosed. So the vehicle could have been in 10 accidents, all of which were under $3,000. That unfortunately doesn't have to be disclosed. Also, how much was the damage, or is it unknown? If the vehicle is new to Manitoba, where was it previously registered? Now, a lot of other places have private insurance. A lot of other provinces will say, some places in the US have private insurance. So sometimes consumers will decide, well, I'm not going to go through my insurance. I'm just going to pay for the repair on my own. So if the repair is paid for on their own, then there may not be a record of this damage or this repair anywhere on the book. So it may not show up anywhere. And that may not be the dealership's responsibility, because if they've done their due diligence in trying to find out the history of the vehicle and nothing comes up, and then at a later time after you've purchased a vehicle, you realize or you find out that it had been in an accident because your mechanic, you were in an accident and the mechanic's fixing it going, this vehicle's previously been in an accident. I didn't know, right? And you might feel that the dealership deceived you, but it might be information that they did not have access to if somebody went and paid for the repair on their own and it wasn't done through the insurance company. Motor vehicle advertising, and this is where we'll get into the fees. Motor vehicle advertising legislation came into force on June 1st of 2015. The legislation addresses all print and radio advertisements, as well as all digital advertisements. It focuses on the all-inclusive price of a vehicle. The requirement is that dealerships advertise the cash price of the vehicle, and it must be inclusive of all mandatory fees. If I go into a dealership and the vehicle is listed at $25,000 and I decide, yeah, it's a good price, it's a great car, I'm going to take it, the only thing that I would have to pay on top of that $25,000, pardon me, is GST and PST. If, however, I decide to purchase an extended warranty, or if I decide I want to purchase a remote starter, if I want to purchase winter tires, those are all optional services that as a consumer, I have the option to purchase. And I decide, okay, this is what I want to buy in addition to that price. No mandatory fees can be added on, no government levies. So something, if you've purchased a car recently, or you're going to be purchasing a car, something that you'll see is usually the tire tax and the AC tax. And together, I think it's $118.75 for those two levies. Those are government levies. I feel like either dealerships don't realize it or they're pleading ignorance, but a lot of them don't include it in their advertised price, and they have to. But that will appear in your bill of sale, okay? Any accessories that have been added to the vehicle, for example, a block heater. If the block heater has already been installed on that vehicle, that advertised price for the vehicle must be inclusive of the cost for that block heater if they're putting it onto the consumer. They can't say, well, we installed a block heater, we added floor mats and mud flaps, and you have to pay an extra $1,200 in addition to the advertised price, right, for this package. Well, no, right? You haven't given me the choice. These are mandatory fees that I have to pay for this vehicle because you've put additional accessories on it as a dealership. That has to be included in the advertised price. However, in a situation in which you negotiate a lower price, the advertising legislation no longer applies. So that same vehicle that's listed at $25,000, if I go in and say, listen, I like the car, I don't want to pay $25,000 for it, I'll give you 20. My salesperson might say, you know what, I can't do 20, but I can do 22.5, right? We'll meet in the middle, we'll say, fine. So we negotiate on $22,500. If I have not specified that I want to negotiate on an all-inclusive price and the salesperson hasn't accepted that, then they are allowed to add their fees onto the lower advertised price. So they can, or sorry, onto the lower negotiated price. So they can add their administrative fees onto the price that you've negotiated that's lower than the advertised price, but they're not allowed to add any admin fees or any mandatory fees onto the advertised price if that's the price that you're paying. Did that answer your question, Ashley, or was there something that I haven't actually touched on with respect to that question yet? You're welcome. Private sales. Private sales are not covered by our legislation as those are consumer to consumer transactions. Okay. So we don't have any jurisdiction in private sales. These are buyer beware. So they don't come with a warranty. They don't come with any consumer protection from our office, so to speak. So what we recommend is a few things. One, take it to get looked at by a mechanic. Two, run a lien check to make sure that there are no existing liens on the vehicle. When you purchase a vehicle from a dealership, they're not allowed to sell a vehicle that has a lien on it. So you know that you're getting a vehicle that is free of any liens. With a private sale, you can make the assumption, but I've seen a number of situations in which things have fallen through the cracks, et cetera, et cetera. Liens follow vehicles, not individuals. So if you purchase a vehicle that still has a lien on it, that lien now becomes your responsibility. And you know, the lender, the creditor, financier, whatever you want to call them, may decide that, well, if you're not going to pay this loan, we're going to come and repossess the vehicle because there's an outstanding balance on it. And they can do that. Okay. So contact the personal property registry. And they should be able to provide you with a lien history on the vehicle. You just need a VIN for it. And I believe there's a nominal fee, and they can provide you with a printout of how that would look and whether or not there's any actual liens registered to that vehicle now. Collection practices. So collection agencies and collectors must be licensed, registered in Manitoba in order to be able to collect from Manitoba consumers. That doesn't necessarily mean that they have to have an office in Manitoba. They can be calling from British Columbia, they can be calling from Alberta, Ontario, anywhere. As long as they have a license to collect in Manitoba, they don't have to be located here, but that license is very important. Our legislation regulates not only the license, but also the collection practices. So there are certain collection practices that are prohibited in Manitoba. The example I have here is calling on Sundays or holidays. The collection agencies are not allowed to call to collect on Sundays. If they do, that is a breach of our legislation. They're also not allowed to contact your family or your friends and harass them to try to reach you. So if, for example, when you took out this loan, you lived with your parents, say, for example, or a family member, and now you're gone, you've moved out, they call that number. Nope, I'm sorry, Silvana no longer lives here. The collection agency may say, and I've heard numerous times in which this has come up, they might say, well, we're going to keep calling you until you have her call us to deal with this situation. They're not allowed to do that. That is a breach of our legislation. Or they say, well, why don't you give us her new telephone number? Your family and friends are not responsible for providing that collection agency with your number. It is their job to find your number and to contact you directly. That's not the responsibility of your family, your friend, whoever you used to live with, to give them that telephone number. So they don't have to do that. They're not breaking any laws by doing that. The collection agency harassing them until they do, that's where the legislation is breached and not compliant. We don't have a definition for harassment in our legislation. That is to be left up to a court of law to define. However, the legislation does state that it is prohibited for a collection agency to call with a frequency or nature that could be considered harassment. So for example, if they're calling 5 times a day and you are answering 5 times a day, the case for harassment could definitely be made. If, on the other hand, they're calling 5 times a day and you're not answering the calls at all, then the reason they're calling is to try to reach you on the phone to discuss the debt with you. Contrary to popular belief, there is no statute of limitations on debts. Debts do not go away, ever. The statute of limitations pertains to how long the debt can remain on your credit report with no activity, and how long the creditor has to sue you for the outstanding balance, right? Which is 6 years. So if I have a debt and after 6 years, nobody's called me regarding this debt, it'll be removed from my credit report. Once it's removed, they cannot put it back on your credit report. So you cannot be penalized twice for the same debt. If, on the other hand, I have a debt, it's on my credit report, and one collection agency calls once every 5 years, that restarts the clock. So if they call once every 5 years, once every 6 years, that'll restart the 6-year clock, because that's considered activity. Even if it's not the right number, or if they send out a letter and it's not the right address, it doesn't really matter. If they've attempted action to try to collect on the debt, that will restart that clock. So it can stay on your credit report indefinitely. But even if it's been removed, the debt still has to be paid, because the debt itself doesn't go away. Internet agreements. We're seeing a lot more online shopping. We're entering into a lot more internet agreements for things we may not have thought that we ever would be purchasing online, but here we are. Under our internet agreements legislation, a buyer may cancel an agreement that they've paid for with their credit card if the seller fails to provide the prescribed information. So if at the time of purchase, you'll get the confirmation email, right? They need to provide terms and conditions, additional charges. They have to give you all of that information as the consumer. If you're not provided with that information, you can file for a chargeback through your credit card company. Additionally, if they do not deliver the goods or services within the 30 days of the specified delivery date, you also have the ability to file for a chargeback through your credit card company. Now, credit card companies are finicky. You only have a certain amount of time with your credit card company to file for a chargeback. So I believe it is, most credit card companies now are 120 days from the last date of promised delivery. So if your delivery was promised October 20th, for example, and then you were advised via email, I'm sorry, we're a little bit delayed, your delivery isn't going to be arriving until October 29th. And then from there, they might say, you know what, it's going to be November 7th. And if November 7th is the last date they give you for delivery and it doesn't arrive, you have 120 days from November 7th to file for a chargeback with your credit card company. If you use PayPal to pay for your internet agreement product, then you can actually file through PayPal and they will reimburse you. However, there's a much shorter time frame, I believe, with PayPal in order to file for that chargeback through PayPal. But if you don't get the item, or if you don't get the item as advertised and you've used PayPal to pay, they will assist you with getting that refund and you'll get it directly from PayPal. Prepaid purchase cards. So effective November 1st of 2007, gift cards cannot have an expiry date except in two specific situations. The first is if the gift card is for a specific service, manicure, pedicure, massage, any one of those specific services, and that gift card can expire. The price of service or the cost of services goes up on a regular basis. So they do have the ability to say, well, we will provide this service at this price up until this date, 6 months, a year, whatever it might be. The other is when the holder provides nothing of value when the card is issued. So for example, you win it as part of a silent auction prize and there's a gift card inside this basket that you've won, that can expire because nothing's been paid for that. But if you get a gift card for a monetary value, $50 gift card, $100 gift card, $20 gift card, $5 gift card, those cannot expire. They are like money, and money doesn't expire. Therefore, the gift card itself does not expire. Prepaid services. As I stated, this applies to services where the consumer is required to pay in advance of using the services. So for example, if I sign up for a gym membership today and I have to pay today for, the next week, 2 weeks, month, whatever it might be, or if I have to pay an enrollment fee today, that is considered a prepaid service because then I'm paying in advance of being able to use the services. And so I'm not going to know if I like the services or not. That being said, our prepaid services legislation does come with a number of protections for consumers. One, it comes with a mandatory 7-day cancellation. So all prepaid service contracts must offer 7-day cancellation, and that information has to be obviously on your contract. In situations in which there is a breach of our legislation. So for example, the written contract doesn't include all of the information that our legislation requires it to include, you as a consumer would have the right to cancel and get a refund of the unused portion of your contract. If, on the other hand, you as a consumer are required to pay in full upfront for, we'll say, an entire year's worth of service, that is a breach of the legislation because the legislation requires that under a prepaid contract, you have a fee payment installation. So you have to pay in installments. They cannot require you to pay in full upfront. Everything has to be paid in equal installments. So if that is breached and you have to pay and you've paid in full upfront, as a consumer, even if you've used the service, you are entitled to a refund of the entire amount back to you. Okay. But like I said, prepaid services, that legislation is very specific to what it applies to. So certain gym memberships, depending on the way in which the payment is set up, dieting plans, dating services, dating or introduction clubs, I believe it actually specifically says in the legislation. Motor vehicle work and repairs. This legislation came into force on July 1st of 2013. The legislation addresses things such as signage. So whenever you go to a repair facility, the repair facility must have I believe it's I think it's 2 feet by 3 feet is a requirement under the legislation. There's a requirement for size and font size as well on the sign, as well as required information that has to go on that sign. And it has to be placed in a visible area. So by visible, I mean visible to consumers. It has to have the hourly rate on there. So what is their hourly rate at that repair facility? Also, it must outline what your rights are under the Consumer Protection Act, and it has our phone number at the bottom. Legislation also addresses estimates. If the estimate is over $100, the repair facility must offer you a written estimate. As a consumer, you have the option to say, look, I don't need a written estimate, but they have to get your authorization, which is the next point. And there is a certain way in which they have to keep a record of that authorization if they don't get your signature on that estimate. So there's legislated information they must keep to prove authorization. The onus is on the repair facility to prove that they received or obtained authorization from you as a consumer for that repair. Now, it's not just like, oh, you need new brakes and routers. Okay, sure, go ahead. If you haven't told me how much that's going to cost, and I haven't authorized the amount, then as a repair facility, you haven't obtained authorization in the proper way, and the consumer may not have to pay for that repair. We also regulate invoices and the information that has to go on the invoices. And there's a warranty that comes with repairs. So under this legislation, the warranty is 90 days or 5,000 kilometers from the day you pick up your vehicle, and it's whichever one comes first. So as I stated, estimates must be offered for work or repairs over $100, and this is the information that it must contain. Sometimes you'll see that the estimate will have spots for all of this information, but maybe your kilometers haven't been included. And that's what I mean by vehicle information, is the kilometers or the make and model of your vehicle, right? It might just have your name and information on it, and then the information for the repair. Technically, that's wrong. But the most important thing on that estimate is the amount that you're being charged and whether or not you as the consumer are okay with that. So they have to give you a description of the work, list of the parts, the type, the cost of each individual part, the total for the labor, as well as the total for the parts, and all other costs. So shop supplies must be included in that estimate. Also, it is required that there's a statement on your invoice regarding exceeding the estimate and authorization for that. And we'll get to that in a moment. So the authorization is required from the consumer in order for the repair facility to be able to charge for the repair. This can be done in writing, fax, telephone, or email. Now, if it is done by telephone, the record of authorization must include the consumer's name, date, time of authorization, and amount that is authorized. They have to keep all of that information in case there is a dispute, and the onus is on them to keep that information, not on you as the consumer. Like I said, the warranty, 90 days or 5,000 kilometers, whichever comes first, on parts and labor. Now, if as a consumer, you are savvy with vehicles, you know parts, etc., so you go and purchase your own brakes and you bring them to the repair facility. In that case, the warranty is only on the labor and not on the parts, because they didn't supply the parts, and so they're not able to warranty or stand behind the quality of the part that you've chosen and brought to their repair facility. The Business Practices Act is another piece of legislation that we administer. This regulates against unfair business practices occurring as a result of making false claims, deceiving, or misleading a consumer. So for example, if you are going to, if you hire a contractor to come to your home and perform certain work, the contractor does some of the work, takes payment, but then never comes back to complete the work, that would be a breach of the Business Practices Act, because that contractor has taken payment for work that they have not provided, right? Services that they have not rendered. Also, if a company offers a warranty on a product or a service, and then they are not willing to honor that warranty, then we could say that that is deceiving or misleading to the consumer, because the consumer believed they had a warranty, and then the repair or the business has stated, well, we're not going to honor that warranty. Now, there's a difference between not honoring the warranty and having the warranty not apply in certain situations, right? Since we were just talking about vehicles, most warranties don't apply to wear and tear items like brakes or batteries. So if you take your vehicle in for repair and they say to you, well, it's your brakes and the warranty doesn't apply in this case, well, that's not a breach of the warranty legislation or the Business Practices Act, because the warranty doesn't cover brakes. Right? The Business Practices Act is only breached in a situation in which there is a warranty to cover the item or the issue that the consumer is having, and the business is saying, well, we don't want to do anything about it. well, then we can look at the Business Practices Act under deceiving and misleading for the consumer. Personal Investigations Act is another piece of legislation that our office administers. This act only applies in 4 situations: insurance, employment, tenancy, and your credit, like credit reporting. So this regulates how personal investigations are conducted. Now, with respect to your credit reports, it talks about, or the legislation, I guess, touches on what is in the report, the process if there are errors, and how long information is to stay on your credit report. The legislation really only regulates how long negative information stays on your credit report, but they can leave the positive information on your credit report for 20 years if they want to, as there's no regulation for that. The Personal Investigations Act states that the information on your credit report must be accurate and factual, meaning that if an item is not reporting properly, you as the consumer should be filing first with the credit bureau in order to get them to fix it. If they're not willing to fix it, or they say, well, no, we've done our investigation and it appears correct to us, you as a consumer then have the right to come to our office, but you should be disputing it through the credit bureau first. Consumers also have the right to a free copy of their credit report every year. If you're willing to wait for it by mail, it takes 5 to 7 business days, 7 to 10 business days, something like that. And you have the right to get one of those every year for free. And we always recommend that consumers consult their credit report annually for free, because you want to make sure that if there's anything on your credit report that shouldn't be there, that you deal with it before you need your credit. So for example, a couple months ago, I had a consumer come to our office. They were looking to purchase a vehicle, and there were all these items on their credit report that didn't belong to them. So the consumer wanted them removed. They disputed it through the credit bureau. Credit bureau says, well, we're finding this to be accurate information, so we're going to leave it on your credit report. Well, turns out it belonged to another consumer who had the same name as this individual. And it wasn't until our office got involved and we started comparing the addresses at which that consumer had lived in Canada that they were able to determine, wait, this is another consumer with the same name but different addresses, and they removed those items. But the consumer was in a rush because consumers trying to purchase a vehicle and they were unable to do so until they had their credit cleaned up, right? I've seen a number of situations in which, well, we've got to renew our mortgage and this item is on the credit report and it's not supposed to be there. Can you have it removed? Sure, but it's going to take some time, right? Personal Investigation Act credit report type complaints are not fast, generally speaking. It takes time because the credit bureaus have to do their investigation. We have to try to figure out what's going on with them, and then fix the issue. And then even though it might get fixed, usually it takes about 3 weeks to show up on your credit report. It can take up to, I should say, 3 weeks to show up on your credit report. Changes of January 31st of 2011, credit reporting agencies are required to post security alerts when requested by the consumer. So if there's been a breach of your information or a suspected breach of your information, your identification was stolen, your wallet may have been stolen, anything like that, your house was broken into, certain documents may have been taken at the time, they are required to put a security alert on your credit report. But you as a consumer would obviously need to call the credit bureaus and ask them to put that information or put that security alert onto your credit report. What that does is scrutinizes any request for credit a bit further than they normally would, just because you've got that security alert. So they need to make sure that it actually is you who's applying for credit and not somebody who's taking your information and trying to use it to obtain credit on their own. As I say, the Personal Investigations Act also relates to employment. And the way in which it relates to employment is if you leave one job, whether it's voluntarily or not, and then you apply for another position and you use your former employer as a reference, if that former employer provides a negative reference that is not factual and you lose out on a benefit, being the new job, as a result of that reference, then you might have a complaint under the Personal Investigations Act. Okay? And I'll give you an example. If I apply for another job and this new position calls my current employer, or the Consumer Protection Act calls my manager there and says, you know, what's Silvana like, right? Do the usual reference check stuff. And my manager says, well, you know what, she's kind of pushy. Nobody really likes dealing with her. She's a real loudmouth, very annoying. Nobody in the office really likes her. That's a subjective opinion about me and what others think about me. I may think that that's not accurate information, but it's hard to prove or disprove an opinion such as that one. If, on the other hand, my boss were to say, well, you know what, she calls in sick once a week, so she's not very reliable and she's late on a regular basis. That, on the other hand, is information that can be substantiated by my former employer, right? And that is a much more solid, we'll say, complaint under the Personal Investigations Act as a consumer than a subjective assessment of what I'm like to work with. So if you receive a negative reference from your former employer, and that is the reason that you were denied this benefit, step one under the Personal Investigations Act is to dispute it directly with your employer in writing and obtain a response. Our office, unfortunately, doesn't have the ability to assist you in getting that job that you lost. However, we will be able to assist you in your future applications with making sure that you're not getting that negative reference check whenever they call your former employer. You also have the ability under the PIA to go to court and sue for the lost benefit if you can show that the negative reference check was not accurate and factual. And that's all I have for you this evening. Look at me, 5 minutes to spare. Normally I don't. If there are any questions at this time that you didn't ask during the presentation, I'm more than happy to answer them, whether it's about any of the information I've provided or anything that you might be curious about that I didn't touch on and you're wondering if our office might be able to assist you or where you might be able to go if we can't.